welcome to another health law policy and ethics seminar series at the University of Toronto Faculty of Law. It's a pleasure to welcome you for a presentation which will be given by Patrick Garon-Sayegh of medical malpractice and methodology, health law research, and the quality of clinical care. I'm very pleased, particularly pleased to introduce Patrick, who is a doctoral candidate at our Faculty of Law, and I have the honor of being his supervisor. His research focuses on the law of medical malpractice, medical legal argumentation, expertise, and expert evidence. His dissertation work, and he will be speaking about some components of his dissertation work, specifically examines how lawyers and medical experts argue in the courtroom to establish facts and determine whether or not malpractice occurred in a given case. Patrick has a Master of Laws and a Bachelor's of Civil Law and Bachelor of Laws, BCL LLB from McGill University, also a Communications Bachelor's from Concordia. He has worked, and this is certainly reflected in his very rich doctoral work, his practice as a lawyer for Mill & Thompson and on an individual basis for several years in Montreal before undertaking graduate research. And interestingly, he's also a music composer and a producer, and he may, in the question period, explain what the connection is to his work, but I think there is a connection. We are very pleased also to have two commentators with an incredible wealth of experience in health law, bioethics, and medicine in general. So Professor Bernard Dickens, Emeritus Professor at the Faculty of Law of our university, who is widely considered, I would say, the father of Canadian and international health law. He's internationally one of the most widely published scholars of health law and bioethics, including on medical malpractice and the standard of care. There's probably no topic in the area of health law that Professor Dickens hasn't touched on. And he currently focuses particularly on reproductive rights in a global context. I could give much more as an introduction, but I think these are the important components to say about Bernard Dickens, who is certainly widely known in our faculty and internationally. So I'm also very pleased to have Ross Upshur, who will be giving a second commentary. Ross is the head of the Division of Clinical Public Health at the Dalla School of Public Health. He's a professor at the Department of Family and Community Medicine. Relevant for this setting also, and again, I could equally about Professor Upshur gave a very lengthy introduction, but he's an adjunct scientist at the Institute of Clinical Evaluative Sciences and evaluated also or involved with the Institute of the History and Philosophy of Science and Technology. Professor Upshur has equally published a ton of articles at the intersections of medicine, bioethics, philosophy of science, public health, and evidence-based medicine. So all of this to say that we will have a very interesting commentary from two different perspectives, which are also reflected in Patrick's presentation, which will focus on the publication he has written in dialogue with a medical researcher who has published a paper as well on medical malpractice. So without further ado, Patrick, please share your screen. And we will have Patrick present, then two commentaries, and then we'll open it up for questions.
All right, well, thank you very much, Trudeau. I believe you should see my slides. And so I'll just begin. Thank you for the kind introduction. And thanks to everyone for being here, especially Bernard and Ross. I mean, I feel really privileged to speak today, but it's a special treat to have such knowledgeable commentators here to keep me on my toes. So I've structured my presentation in two main parts. The first part is the shortest. I take a few minutes to talk about the articles that were assigned as readings. I don't spend much time on the articles because I imagine that not everyone present has read them, and I want my talk to be for everyone. I also have other reasons to not focus too much on the articles, and these will become clearer as my talk unfolds. That said, I'll be happy to take questions and hear comments on the papers afterwards. The second part of my talk takes up the most time, and in it I discuss two methodological views or approaches that can be taken by researchers when thinking about malpractice. In addition to simply presenting those views, my goal is to show you that what we call medical malpractice looks very different depending on which view one takes. So, starting with the articles. The first article was by Ashley Szabo Eltorai. I apologize if the pronunciation isn't correct. And the second was by me. I'll cover them briefly by telling you why I ended up writing my article, which, as Trudeau mentioned, was largely written in response to Eltorai's. So I initially read Eltorai's article because my dissertation focuses on medical malpractice, and I'm always keen on hearing what physicians have to say about it. But when I read Eltorai's article, it seemed really strange to me. It wasn't talking about malpractice as I understood it from my perspective as a litigator. Now, that was okay because the paper wasn't necessarily about malpractice, but about studying malpractice to improve quality of care. But it didn't seem to be talking about quality of care either, at least in some respects. Why? Because as I say in my own paper, avoiding malpractice doesn't necessarily mean providing good quality care. These are two different things. They can overlap, of course, in the sense that good quality care will typically not lead to malpractice lawsuit, but it seems to me that these two things are distinct and should be kept distinct. That's the first thing. Second, I was struck by how her recommendations at the end of the paper were very thin and heavily qualified. So I wondered, among other things, why bother with this statistical analysis? Is such an exercise ever useful? And more importantly, for whom is it useful? So in some of the articles seemed to me far removed from both medical and legal practice. It wasn't really talking about medical practice because its source data were legal materials, but it wasn't really talking about legal practice either because it didn't engage in legal analysis. Now, at the time of writing the paper, I was insecure. I was at the beginning of my doctorate, whereas I'm now at the end. I'm still insecure, but I think a little bit less. At the time, I was criticizing a medical paper by a physician writing in a medical journal. And so my instinct was to get into lots of technical details about methodology. I won't rehash them here because that would take too much time, and I would just be repeating what I think is more or less reasonably well laid out in the paper. The gist of my criticism is that the data used for the statistical analysis are so far removed from what happens on the ground, either in law or medicine, that it's anybody's guess as to whether or not the statistical analysis tells us anything about what's happening on the ground. And I argue that researchers who care about either malpractice or quality of care should pay close attention to what happens on the ground. So to make this argument, I take a more meta perspective on the literature and place the two articles within this meta perspective, which I've gained over the years. Thanks to this meta perspective, I can now articulate what was bothering me about Eltorai's paper more clearly than I did when I wrote the paper. And if I were to sum it up in a single sentence, I would say that I have a problem with the methodology she used because it makes a lot of important things invisible. So to flesh that out, let me move to the two approaches. The first approach, I call these two approaches the systemic approach and the observational approach. And I've structured the rest of my talk around a series of binaries, which I think are helpful to get a full sense of the contrast between these two approaches. So Eltorai's paper can be taken as exemplary of the systemic approach, whereas my paper can be taken as exemplary of the observational approach. Or at least I now see that that's what I was gesturing towards at the time I wrote the paper without yet having the words to say it. I'll begin by digging into the systemic approach and then contrast it with the observational approach. Now, I think it's safe to say that the systemic approach is the dominant one in the malpractice literature. It is most famously exhibited in To Err is Human, Building a Safer Health System, which is a much cited report prepared by the US Institute of Medicine. It can also more recently be seen, and this is just an example, in the UK's Patterson inquiry, but more generally, it can be seen in the vast majority of articles published in medical journals on the topic of malpractice. This entails that the majority of writing on malpractice by physicians tends to follow the systemic approach, as well as most writing by health law and policy specialists. Now, the title and subtitle of the Institute of Medicine's report is quite apt because it contains pretty much all the keywords necessary to get an overall sense of the systemic approach. First, or rather last, is the term system. It will come as no surprise that the systemic approach is concerned with systems. The approach highlights how many areas of human activity take place in what can be called socio-technical systems. These systems are highly complex. They have many different components that aren't perfectly matched to one another. If we imagine such a system as a machine, a metaphor that underlies much writing in the systemic approach, then it is a clunky machine whose parts are cobbled together by a bunch of tinkerers using what they had on hand at the time. The ideal goal of the systemic approach researcher is to move from tinkering to engineering.
I get my picture shown here.
The goal, oh, sorry, I'm hearing. The ideal goal of the systemic approach is to move from tinkering to engineering. The goal is to engineer the clunky machine into an iPhone, a marvel of rational organization, where each part is perfectly fitted to each other to form a smooth, shiny, near perfectly running whole. Now, the purpose of this rational organization of a system is essentially to reduce risk, to build systems that are safer than the ones currently built. Note that the healthcare system is just one such system. Indeed, the systemic view isn't limited to healthcare. It's largely built on what is sometimes called normal accident theory. This is essentially a blend of organizational theory, cognitive psychology, and human factors engineering. That is why you'll see systemic thinking in all sorts of other areas beyond healthcare, such as in the aviation industry, which brings me to another prominent example of systemic thinking, checklists. Checklists are a big deal in aviation, for example. And Atul Gawande, who's a famous surgeon at Harvard Medical School, wrote the Checklist Manifesto, making the case for more checklists in healthcare. This brings me to another key aspect of the systemic approach, which can be seen in the first part of the title of To Err is Human. The systemic approach comes with a certain conception of medical error. Errors are normal in the sense that they are a normal part of the system. Accidents are also, therefore, a normal part of the system because the system isn't perfect. And it's the gap between perfection and reality that generates risk, which then materializes into error.
This is fine, thanks.
Now, so far, this only says that errors are a function of systems.
Oh, yes.
Why say to err is human? There are two aspects to this. First, systems are built by humans, and so the gap between perfection and reality is ultimately attributable to human failings in planning and rational organization. But more fundamentally, the systemic approach is often buttressed by lots of cognitive psychology, which shows how our human brains, even the best brains, the brains of physicians, are riddled with all sorts of biases. Here, a recent book by Jonathan Howard is a good case in point. He's a professor of medicine at NYU who discusses at length how physicians are susceptible to all sorts of cognitive failings. So from the systemic perspective, things like checklists and other systemic interventions are often there to keep fallible human brains from messing up. Among other things, systemic interventions are there to keep human actors on the straight and narrow track towards the system's goals, regardless of what those goals might be. In aviation, it's getting human bodies up in the sky and back down again in one piece. In healthcare, it can be improving population health, lowering the cost of healthcare, reducing the number of injuries, etc. A striking example of something calling for systemic intervention is the malpractice crisis. Now, this is mostly an American thing, but it's not unheard of in Canada. There are countless articles on the malpractice crisis. The general idea being that malpractice litigation costs the system a fortune, that this is unsustainable, that it reduces access to healthcare, et cetera, et cetera. The malpractice crisis perfectly illustrates the last two features of the systemic approach that I want to point out. First, the systemic approach overwhelmingly privileges quantitative analysis. Indeed, whether or not there is a malpractice crisis rests on the analysis of quantitative, often economic data. These data are compiled from thousands, even millions of individual events. Second, the systemic approach and systemic interventions are top-down. The view is, quote, from above. It tries to see society or the system as a whole. And systemic approach interventions are implemented following policy decisions, or they are legislated. I think that's part of the reason why the systemic approach is so dominant in the field of health law and policy, which is often more about policy than it is about law. What I mean by this is that insofar that the discussion is about law, it tends to be a policy-oriented discussion aimed at legislative or regulatory intervention. On the issue of malpractice, for example, the recurring subjects are things like tort reform, no-fault compensation regimes, the fiscal sustainability of healthcare, etc. All stuff that are happening in the realm of legislation. Now, to be clear, this is just a broad brush portrait. There is room for plenty of nuance here. And nonetheless, I think this portrait captures what is going on in a huge amount of literature in health law and policy. Indeed, I think this portrait is probably instantly recognizable to most of you because it's the way in which so many public discussions surrounding healthcare are carried out. I insisted on setting out the systemic approach first because the observational approach might seem counterintuitive. Now that I've given you a sense of the systemic approach, I can use it as a foil to present the general contours of the observational approach, and after that move to a specific example of the observational approach in order to unpack some of its implications for how we can think about medical malpractice. So start shifting towards the observational approach. Consider the last two features of the systemic approach I just mentioned. The systemic approach is quantitative and top-down. In contrast, the observational approach is qualitative and stays on the ground. Now, quantitative approaches, by their very nature, abstract away from the ground, from local and specific contexts. Indeed, they need to cut across context in order to get a view of the big picture or the whole system. That's the point. As I said earlier, the only way to see whether or not there is a malpractice crisis is via the collection of data points across thousands of specific situations. Another key aspect of systemic and quantitative approaches is that they require decision rules and definitions that can be applied across contexts. So in order to count things, you need to define in advance what it is that you're going to count. Without such rules and definitions, you can't get the overall count that you need in order to do your quantitative analysis. If you want a quantitative analysis to mean something, you can't just count anything. You have to count specific instances of things that are rigorously defined in advance. So research in the systemic approach tends to have a precise definition of medical malpractice and medical error. There is no single dominant definition. There are a number of them in the literature, and I don't need to review them here. The point is that the systemic approach and research within it presumes that medical malpractice or medical error is a stable concept, or at the very least that all we need is a good stable definition of the concept. Here is where I could shift more specifically to the observational approach and what might make it look so strange. In the observational approach, error and malpractice are essentially contested concepts. That is, these terms do not have an empirically stable reference. Now, before explaining this further, I need to qualify that a little bit. There are, of course, obvious errors. Amputating the wrong leg, for example, is an error and malpractice. You don't need to be a lawyer or a medical expert to understand that. It shouldn't happen, but it still does, along with many other kinds of obvious errors. I'll call them blunders. Under the observational approach, blunders aren't interesting. They aren't interesting precisely because pretty much anybody can see that they're blunders. The thing is, the terms error and malpractice also apply to plenty of cases that are not blunders. Physicians, and any other professional for that matter, I'm just limiting myself to physicians here for convenience sake. Physicians routinely disagree as to what should count as an error. In other words, what counts as an error is very often not obvious to anyone. When push comes to shove, physicians might state their opinion as to X being an error or not, but other physicians will routinely disagree. So to take the observational approach is to closely examine how physicians come to determine what counts as an error in specific cases. It takes the essentially contested nature of the concepts of error and malpractice as given and observes how individual physicians, either alone or together in members of a team, identify specific cases as errors or malpractice. Now, what does this look like? Simply put, the observational approach relies on a combination of ethnographic observation and interviews. It is, once again, a form of qualitative research. And here I can shift to my example, which is Charles Bosque's wonderful book, Forgive and Remember. This book is an ethnography that is exemplary of the observational approach. I can't recommend it enough. Anyone who wants to deepen their understanding of medical practice will benefit on some level from reading this book. Now, what did Bosque do? Since his study takes an entire book, there's a lot to say. To best understand his findings, I'll give you a bit of context and say that he embedded himself for many months in a surgical residency program in order to figure out how surgeons learn what proper surgical practice requires. Now, the choice of a surgical residency program was very apt for the following reasons. Of all medical interventions, surgical interventions are the ones that happen in the most compressed time frame. They are the most targeted and visible interventions, and they are the interventions for which success and failure can be evaluated relatively close, quite close often, to the intervention. In contrast, internal medicine interventions are more spread out in time. There's much more wait and see involved because individual pathophysiology can be highly variable. Physicians need to allow drugs time to do their thing. They need to get test results, make new test results, et cetera, et cetera. So in principle, and generally speaking, of course, it's much easier to spot an error in surgery than it is in internal medicine. It's also much easier to pin a bad outcome on the surgeon than it is on an internal medicine physician. So Bosque observed how surgeons in training come to know what counts as an error. Clearly, they learned this in residency, because if residents already knew what counts as an error upon graduating medical school, then residency training would have no point. So residency training is about learning what proper surgical practice requires. It's where surgical trainees are inculcated or socialized into the standards of care. This inculcation is the task of the attending surgeons. Attendings are at the top of the surgical hierarchy in the hospital. They're in charge of the patients. The residents are beneath them, ranked by seniority. As residents gain in seniority, they gain more and more independence. But the attendants have the last say on everything that goes on in the surgical service that they're in charge of. Importantly, it's the attendings and no one else who decides what is an error and what is not an error. They're the last word. They're literally the judges of surgical error. So once again, all this makes the surgical residency program a perfect location for observing how determinations of error are made. What did Bosque find? He found a lot of things, of course, so I'll limit myself to a few key points. First, he found that there was a degree of stability to what counted as an error between different attending surgeons. So if a resident got chewed out by an attending for doing something, one could fairly expect that another resident who did the same thing would get chewed out by the attending's colleague working in the ward next door. But on what grounds did attending surgeons decide what was an error? This is where Bosque's findings are most interesting and striking. Simply put, Bosque found that there were essentially two kinds of errors: technical errors and moral errors. Technical errors are simply errors of surgical technique, such as cutting the patient too deeply or not tying knots tightly enough. Interestingly, technical errors were forgivable. Indeed, technical errors need to be forgivable because they're unavoidable in medicine, which is rife with uncertainty. Such errors are all the more possible in a surgical residency program because residents have to be given some room to make mistakes. Otherwise, they'll never learn to be independent. Moral error, on the other hand, is not forgivable. Moral errors occurred when residents did not act in a way that was commensurate with the responsibility that comes with the role of a surgeon. Most importantly, what counted as a moral error was not set out in rules and definitions specified in advance. There was no textbook, guidebook, or manual. Whether or not conduct counted as a moral error rested upon whether the attending considered the conduct to be blameworthy. This could not be reduced to rule following because the blameworthiness of conduct depended heavily on the contextual particulars of each situation. and medicine is full of particulars. So the crucial distinction made by attending surgeons did not concern technique at all, but moral blameworthiness. It was blameworthy action that discredited the residents in the eyes of an attending, not technical failure. Note, however, that multiple repetitions of technical failure could eventually be indicative of moral failure. Why? Because it suggested to attendings that the residents were not putting in the effort to learn from their technical mistakes. And lack of effort is a moral failing. From this, I can introduce my last binary. The systemic approach focuses on harm, whereas the observational approach focuses on wrong. And since I'm speaking to an audience that's partly at the Faculty of Law at the University of Toronto, I'll add that this binary overlaps with two different conceptions of justice: distributive justice and corrective justice. Corrective justice being very famously defended by people such as Arthur Ripstein and Professor Weinberg. Now, this is obviously too big a topic to cover here, but I want to say a few words on it before wrapping up. On the systemic view, harm is the materialization of risk that is inherent in the system. Harm is normal because the system isn't perfect. It just happens. The goal is thus to lower the risk in the system in order to reduce harm for everyone. When harm materializes in specific instances, it isn't anyone's fault. It's merely a manifestation of the imperfect working of the system. Note that this also applies to the individual physician, whose cognition is also imperfect because of biases. Harm that is due to brain failure is not blameworthy. This points to another reason why the systemic approach is so popular. It's seen as more enlightened, more progressive, more scientific way of dealing with medical injuries. Why? Because part of its stated intent is to move away from blaming and shaming. The logic is the following. If we know that human systems and brains are imperfect, how can we blame individuals? It's not their fault. Harm happens. Let's figure out a system for dealing with it. On this view, the law of medical malpractice looks very out of step with the times because it's seen as being all about blaming and shaming individuals. And the observational view might seem like a backwards attempt to vindicate blaming and shaming, but it isn't. It's about observing how contextual particulars matter in individual cases and how physicians come to make actual concrete determinations of what is the appropriate course of action. And concrete determinations of courses of action in particular cases are deeply moral because they rest on valuing and ranking innumerable particulars that are often incommensurate and cannot all be specified in advance. So the problem with the systemic approach, in my view, is that it is more or less completely blind to the importance of contextual particulars. Indeed, it has to be blind to contextual particulars because it needs transcontextual definitions and decision rules to do its thing. The consequence of this, however, is that while the systemic approach makes certain things like the malpractice crisis visible, it makes the moral dimension of medical malpractice invisible. The physician-patient relationship, need I remind everyone, is a fiduciary relationship. It's a moral relationship that comes into its own in particular cases. The observational approach, therefore, serves as an important counterpoint, a reminder that the physician's duty of care does not reduce to decision rules and protocols. Now, I don't have anything against decision rules, protocols, or checklists for that matter. And I have nothing against the systemic approach. But if it becomes the only lens through which we think about malpractice, we then become blind to things that are hugely important to both medical and legal practice. So I think that's a good point to stop. I will turn it over to my illustrious commentators, who I think have no doubt a lot to say. And your questions, and I thank you in advance.
Yes, thank you very much, Patrick. I will invite Professor Dickens. Bernard, could you unmute yourself, please? I muted you because there was some interference. You have to click on the microphone. Okay, so I can't do it from my end, I think. Just a second, I'll see if I, so ask to unmute. Yeah.
But
Okay.
the microphone is gone. Can you hear me?
Yeah.
Yes, very good. Working. Okay.
Good. Well, first to congratulate Patrick on an excellent introduction, probing what it is about medical practice that makes it malpractice. That is, if we accept that error of judgment is one of the incidental characteristics of decision-making, then we have to identify, if we can, what it is about the practice of medicine that violates legal standards. And taking this from the case law is helpful, but it's in many ways not sufficient. It has, for example, been helpful when courts, in cases where sponges or instruments were left inside surgical patients, were a result of there not being someone attending surgery, keeping note of the number of sponges used and which instruments were used, and doing a sponge count or an instrument count before the patient was sewn up, to conclude that this was negligence. That is, the surgical professions quickly picked up that if there wasn't a sponge count, if there wasn't an instrument count, and sponges or instruments were left in, then that's going to be negligence. Part of the interaction we have to deal with is the contrast between making wrong decisions and making decisions wrongly. That is, a decision could be wrong in scientific terms, and this is something that perhaps Ross will deal with. If a decision was made wrongly, that is, by failure to observe the prevailing, the expected standard of care, if factors were taken into account that should not have been, or factors that should have been considered were left out of account, then that is making decisions wrongly, and that could be a source of liability. We also have the problem of the structure of litigation. Patrick has put it in terms of doctor-patient relationships. But sometimes there can be conditioning factors that, in a different sense in which Patrick used it, which are systemic errors. For example, if doctors are overworked, if they're not given breaks when they need them, then they become tired, they forget things they should take account of, they forget to do things that are necessary to do, and that will result in an error. And when it's a cause of harm, that is going to be a successful focus of litigation. One of the problems of litigation structure, doctor against patient, is that sometimes the doctor did the best that the doctor could do in the circumstances, but the circumstances were defective because of institutional pressures. We find these coming from a lack of resources, economic problems. There can also be cultural or political problems. For example, the wait times for surgery will be a form of reputational damage to the hospital or to the healthcare system if it takes too long for patients to have their surgery scheduled, then that's going to be a fault in the system. And so to keep time limits, pressures are put on surgeons to be available, perhaps to undertake procedures when they're tired, to undertake procedures that are beyond their skill level, beyond their experience level. And that could result in errors for which the doctor named in the litigation will be held liable, when the fault is really on the hospital system, the health system that set the scene for that. A study of malpractice cases, although instructive, leaves out of the question the cases that are settled out of court or the cases that were not pursued when they might have been. For example, the health insurance plan in Ontario follows what its name indicates, insurance principles, subrogation. That is, it's OHIP that drives the litigation that perhaps will recruit and identify the lawyers who are going to take the case. And if the assessment by the insurers, OHIP, is that the case couldn't be won, then it won't be brought. Equally, we have to look at the role of the Canadian Medical Protective Association. The annual report has a commentary by legal counsel to the Canadian Medical Protective Association showing what they have learned. And the CMPA may conclude by its own expert assessment that the case is indefensible. And in that case, they will offer a settlement, perhaps without going into litigation, or an out-of-court settlement. And the terms on which settlements are made and the extent of the settlement will be a measure of the incidence and the extent of the fault identified within the profession by the experts guiding the Canadian Medical Protective Association. And those cases won't appear in the law reports, and they won't be amenable to the sort of analysis that Patrick and others focus on. But consultation with the CMPA, whose offices in Toronto are in a law firm or were in a law firm's space, could be guidance to the identification of fault within the profession, within the medical profession. In that sense, then, doors have been opened wide by Patrick's splendid presentation to separate error, which is incidental to the practice of medicine, from making blamable, blameworthy mistakes, malpractice. And the data could be very extensive and open to different levels of analysis and perception. The interaction of harm and wrong is important. Harm would be the basis on which injured patients and their families would propel litigation. It could be that decisions are made that are wrong in principle, but not wrong in effect. That is, the error maker could get lucky in that there was no injury, and that is often described outside the law as getting away with it. This is something that's always troubled me. When years ago I was taking a small group in criminal law and would deal with cases in which there was an acquittal. And the student would say, oh, the defendant got away with it. I'd have to say, no, the defendant was held not criminally liable. There was nothing to get away with. And this is something that reverberates in the context of medical practice and the intersection of practice and malpractice. So there's much to study. I'm delighted that Patrick is getting into this. He is fashioning his thesis. He's also fashioning his future career. And this is something that we will monitor with great interest and admiration for the level of analysis that's been conducted to date. From the trenches, Ross will be able to deal with this in a less ivory tower way.
Thank you very much, Bernard, for these very nice words and interesting comments. We go now more to the combination of the trenches and the ivory tower of academia. So Ross will be able to connect the two.
Thank you very much. And thank you, Patrick, and thank you, Bernard, for setting the stage for what I hope may be useful comments. I'm going to take a point of departure from the very last comments that Professor Dickens made about the error maker getting lucky. As a 30-plus year practicing clinician, I have indeed been an error maker. And I believe I have also been fortunate not to have so much gotten away, but not done grievous harm by some of the errors that I may have made. Because of course, as Patrick has pointed out, clinical medicine is a very chancy, very risky, highly error-prone, uncertain undertaking. It's one of the few, as I teach my residents, when you become a physician, you can do everything absolutely correctly and actually harm or potentially kill your patient because one, certain conditions may present in as if they are an A and in fact be a not A. So you may mistake a simple common condition which presents to something that might have lethality. Now that won't necessarily come to the level of malpractice, but I want to commend Patrick for his work. He's been deeply engaged and is now co-leading the Philosophy of Medicine Working Group and bringing the really important and exciting world of law into the philosophy of medicine. So there's an intersection of scholarship in bioethics, law and legal analysis, and philosophy of science that Patrick's work represents, which I think is really groundbreaking and really exciting for people who are involved in these forms of scholarship. So I want to thank Patrick for bringing his insights to our group and the contributions he's made in his leadership of the group. And to that point, I just want to sort of come back. You say you've raised things as kind of binaries, and I think they're not quite as separable in many ways. I think they're actually, if I wanted to steal a fancy philosophical term, I think they're in some form of dialectical relationship. In other words, and I think your concern is appropriate, where what you call the observational or the qualitative or the grounded or the lived experience, there's a large number of frames that we could use, seems to risk being obscured or eclipsed by the kind of monolithic, powerful, well-resourced, hegemonic tendencies of the systemic view rooted very firmly in quantitative conceptions of what counts as evidence. And what you're picking up on there, I think, is something that I've been concerned with over the past 25 years, particularly with the advent of evidence-based medicine and the way it has played out to and actually functions in the world that you're operating in which you have this marshaling of quantitative evidence ranked according to study design in terms of its quality. And that feeds into guidelines, and then guidelines increasingly become the source of what is expected as a standard of practice. And so that form of reasoning and thinking actually has a tremendous on the ground influence. And in other words, that kind of motivation, and that's why it's compatible with this systemic view or systematic view that you have articulated. And it actually does affect how decisions are made on the ground, because now people will say, what does the guideline say? Why did you deviate from the guideline? And I wrote a paper a few years back called Looking for Rules in a World of Exceptions, where I point out that, there's some very fundamental insights from, people like Osler. You treat the patient, not the disease, and patients are as heterogeneous and different as everybody here at this seminar. And so this tension between the exercise of good clinical judgment, which is sort of, as some people have claimed, the exercise of phronesis or practical wisdom, which is to take some of these general and universal concepts from the science of medicine that the quantitative tradition represents, and apply them to the particular individual, is the exercise of clinical judgment. And I was grateful to you in your paper for citing a couple of papers where we tried to articulate the importance of this, of keeping both of these polarities in mind, that you don't simply rely upon the systemic view. You need to be attentive to the particularities of the individual. And that raises the issues that I think you nicely point out in your critique of the Ulteri paper, that their claims were overstated, that the statistical analysis didn't actually support the inferences that they wanted to, because the sample that they were drawing from was so highly skewed to begin with, that it's hard to see how that sort of analysis would actually link to improving the standard of care. So intermediate to and the means by which I think these two traditions connect is in this notion of quality improvement, or now what people are talking about, implementation science approaches, where you really understand the importance of context and altering and understanding context in terms of interventions. So one of the things I would like you to actually speak to a little bit more, and what I found fascinating, was your analysis of causation and the distinction between how causes are legal causation and medical causation, and how they're different and at variance in important points, because I think having that understanding of causation in the field, particularly of malpractice, is critically important. I think this is where you have the opportunity to really robustly bring in thinking from philosophy of science and a long literature and reflection on what causes are and how causes may function, and bring that to bear upon important issues in philosophy of law and your approach to malpractice, but also I think to how we understand causes in medicine. So I commend you for your work, and I want to give you time to respond to Professor Dickens's comments in particular. I don't think I've added anything of illumination at all, except to know that now that I am a fortunate and lucky error maker who is always going to be mindful of that capacity, and hope I never have to be in the offices of the CMPA anytime soon. So thank you for the opportunity to participate.
So thank you both for very interesting complimentary comments on Patrick's presentation. So Patrick, maybe if you could give some brief comments, some thoughts about the two commentators, and then we'll open it up for questions. I have a list of questions I already received from students we can get into later, okay?
Perfect. Well, okay. Well, thanks for everything, Bernard and Ross. I'll just quickly make a few sort of overlaps and rehashing what stood out in both of your comments. So both of you mentioned the dimension of clinical judgment, which animates really my approach a lot, and thinking, taking clinical judgment seriously as something that has to be done. And so that's definitely sort of one important theme, and it's something that I fear when I read systemic approach literature, which once again, the point is not to say that it's bad. It's to say that, well, if when you read this literature, there is no clinical judgment. It's just there, like it's not there. It's invisible. It's not a phenomenon that is either necessary or what, it's just not there. I really liked Bernard's distinction, which fits very nicely into the binary structure that I had. So the idea of wrong decisions versus making decisions wrongly. I really like that one. It's another. I'll work on it, but once again, it fits very nicely in what I was trying to say. The point made by Bernard regarding, let's say, the CMPA and how the CMPA makes decisions, and I mean this. I talk about it a bit in my paper, where I say, look, there's tons of decisions that happen upstream from any sort of legal kind of judgment. So the difficulty, the main methodological difficulty I had with Elterai's paper was this, taking this the last sort of point in this chain of things that had happened upstream, and we don't know what happened upstream at all on so many levels. And so what I would advocate for eventually, and I know that this is probably not even possible, or if it is, it'll only be possible by somebody like me after many years of gaining credibility as a scholar, will be to actually do ethnographic research and interviews at the CMPA to see, these are real human beings at the CMPA. They get together, they have a file, they do their own investigation to decide what is defensible and what is indefensible. And that determination is once again something that is open to observational analysis. Not concretely, somebody makes this decision either together or by committee or by some sort, like there's a process. How? This is a question for that the observational approach this is where you deploy the observational approach to ask those questions. Turning to, just going quickly to turning to Ross, this idea that you said, I perfectly agree. So my binaries are there, my sort of keyword oppositions, I find helpful to, structure a 20-minute, 25-minute presentation. It was a good way to, I found, to set up the story. Now, of course, these can be, dialectically deconstructed in so many wonderful, wonderful ways. One of them being, so what do we consider to be on the ground? So an interesting twist that I would say is that if you are, and I think, well, Ross is the perfect person to be talking to about this. So if the subject who is making the decision, who's making choosing action, is a public health physician in charge of taking a decision for a large population, that is also a moral decision that requires judgment, but that cannot be done without a massive quantitative data. So, that's just one example among many where I don't want this to turn into some sort of, quantitative versus qualitative, chicanery. They both interact, same as what you were saying, Ross, of course. So how does the meta-analyses and randomized control trials and all of the stuff that gets churned out by the machine of EBM, how does that stuff materialize in the clinic, like on the ground? This is mobilized by actual physicians as they're doing their thing. So one of the things that I do in my dissertation is, part of my motivation was to say, okay, well, how do medical experts actually mobilize? Or do they mobilize? And if so, how and to what extent? And how do they mobilize randomized controlled trials or clinical practice guidelines or so on? Because once again, this is in the process of determining whether or not conduct was blameworthy or not. So anyways, these are some, the causation, the causation question, Ross, I think I will talk about it some more a bit after perhaps. I will say though that I thank you for flagging it. I think that the main thing, the way I'm conceptualizing it now, to say it briefly, is that what we consider what is causal in law is has a moral and value dimension, and that's, I think, a sort of a kind of inescapable sort of observation that I sort of talk about cause and fact, cause and law, but so there's these different levels at which we can analyze causality, and I think that the kind of causality that, let's say, lawyers are interested in a litigation context will not necessarily be the kind of causation that physicians are concerned with in the clinic. Sometimes yes, sometimes no. Like this is a really interesting and complex area. So far, I've been able to kind of skirt my way around causation a little bit because, as it happens, I have enough to write an entire dissertation on the standard of care. There's enough just on the standard of care to do a whole dissertation, so I'll leave causation for my next book and damages for the next generation. So thanks again to both of you for these comments, and Trudeau, I'll let you usher in the rest.
Very good. So thanks very much. We forgive you for not tackling in detail the causation issue, because that's indeed another 10 hours of discussion for sure. So I will open it up for questions now. As those who attend the seminar regularly know, I receive questions beforehand from students who are taking this public seminar as a course. And so I will allow several students first to ask some questions, and then we will open it up for the broad audience. But if you have questions already in between, feel free to write them in the chat box. I will try to keep track of questions that are posted there, but otherwise, certainly after while we are going on, you can put up your hand, and I'll keep an eye out to who else is asking questions as well. So let me open it up with asking Kim Goebbels to formulate one of her questions.
Yeah, for sure. So thank you for the presentation. It was super interesting. As you know, we read 2 articles before coming into this class or seminar today. And in your response to the first article, you emphasized that caution should be taken when using legal evidence to make conclusions with respect to quality of care. So from like a research perspective, if I were someone kind of wanting to look into the history of quality of care, without any like formal database that doesn't disclose patient information, but that's confidential, but discloses kind of all of the other information, there's obviously always going to be informational biases and inefficiencies. So what would you recommend research do to study the quality of care in medicine when these data sources aren't necessarily easy to come by?
Well, thank you for that question. So I would say it depends. There are a few sort of basic questions. The first is, how much time do you have? What is feasible? What are your available resources? But I would say even before that, I think that the systemic versus observational orientation is an important one. And I think that it's kind of career defining. I don't see myself ever doing systemic quantitative research. And I mean, I have nothing but respect for people to do that kind of research, but I think you need certain kinds of skills, namely quantitative skills that I don't have. I've worked on developing a whole other set of skills, learning about a whole other literature, and sort of thinking in a whole other way. And so the choice between systemic versus observational, I think, is really found in some cases foundational. I'm sure, there's, once again, I don't want to be overly insistent on segregating these two approaches. There's all sorts of interesting mixed method things, and you can do there are teams of researchers that can do all sorts of fun stuff. But I'm just saying here, let's say if you're an individual, you want to, as a solo researcher, how you're going to go about it. I think it's really important to get a sense of what kind of research path is of interest to you, and in making that choice, I would say the following: who do you want to talk to? If you want your research to speak to the Minister of Health, then I strongly recommend you go for systemic quantitative approaches and figure out how to, do whatever it is you want to do with numbers and get really good at that, because that's what will get the minister's ear. If you can knock on the door, it is very simple. If you can knock on the door of the minister and say, "Hey, minister, I can save you $1 billion, or I can reduce, in healthcare costs, or I can reduce injury by 13.9%. Minister will listen. If I knock on the door and say, oh, by the way, it's an error is an essentially contested concept, and here's a book-length ethnography, they'll say, get out of my office. However, I think I have so far a degree of purchase with physicians who are clinicians, or lawyers who are litigators, people who think in cases and who deal with actual cases. And so I think that, once again, it's really fundamentally an audience thing. I think if you're sort of thinking about how do I orient my research path, I think that's sort of an important kind of quasi-existential question to ask oneself as a researcher. I hope that helps.
Right, yeah, thank you.
Okay, I would invite Safa Warsi.
Hi, yes. Can you hear me?
Yeah.
All right.
Yes.
Yes. So we covered that slightly, but you talked about the methodological errors in Altarai's article. So from my understanding, the US has a more litigious culture when it comes to medical malpractice. And I was just sort of wondering how you think that might factor in to the methodological study, and whether there would be a difference if you perhaps looked in a Canadian context.
Thank you for that. So what I think, so my sense is that as a Canadian lawyer, my sense is that there might be, and I say might be, a more litigious culture in the US. I say this because of what I read in the literature, but what's interesting is that our idea, the claim that the US has a more litigious culture is a kind of an empirical claim that you can only make with systemic sort of, to say that there's like a more litigious culture, usually people are going to say, oh, there's like X billion dollars in litigation or whatever. It's a claim that is based on large scale numbers. Maybe, and I haven't looked at this. Now, maybe there's something in how Americans think, actually on the ground, and that American lawyers are a bunch of ambulance chasers, and that's really a thing. And this is on the individual level. This really has a a higher, it motivates a lot more individuals to individual lawyers to how do you say, to chase ambulances. Once again, if it's insofar that you're making a claim as to the scale of the phenomenon, then you're going to need some sort of quantitative data. I wonder whether, I don't want to question, so I think it's an orthodoxy that, like, and I'm kind of willing to go along with it, that US has a more litigious culture. But sometimes I wonder what that means in some respects, because you can, I think that if we were to speak to a malpractice lawyer in the US, who once again is dealing with individual cases, is it really so different? The tort law is pretty much the same. Now there's obviously variations from state to state and all sorts of weird things that, but generally speaking, they still have the duty of care, standard of care, causation, and damages, the same kind of structure. Do they think about that in such fundamentally different ways as we do here? I don't know. Another thing is also, we can add to that, is that they have more jury trials than we do here. So in Quebec, there are no jury trials in malpractice cases. I know in Ontario, there are some cases that are by jury. There are some that are not. Does that change something? I just have a bunch of, I have many questions. So from an observational approach, it's not even really intelligible to talk about the United States, as far as I'm concerned. You're gonna go to the courthouse of Philadelphia, Pennsylvania, or talk to lawyers in such and such a law firm, and do your ethnographic research and interviews there, and then think and see what you can extrapolate as more general lessons. Once again, I can only say, read Charles Bosque if you want, stunning example of what can be done with observational research.
Thank you. I now go to one question which represents actually three or four different people who asked more or less or along the same lines a question. I'll invite Dina Nixerecht to ask her question.
Sure, thank you. So my question just related to the discussion of the causative factors that you spoke about in your article. And so I understand the concerns with using databases that contain filed lawsuits and how they consist of alleged causative factors. However, if we're referring to databases of legal judgments, then can we not be confident that these judgments are providing us with the real causative factors and not alleged causative factors?
Well, thank you for the question. So I don't think so, because once again, for everything is alleged. If you're litigating, you're making allegations. Everyone is just making allegations, which I don't want to seem like diminutive when I say just. That's how litigating works. Lawyers go out, collect documents, speak to people, do whatever it is that they need to do to try to build a case, either for the plaintiff or for the defendant. And this is after the fact, and sometimes much down the line, time-wise, months, sometimes years after the event. What I was trying to get at with the real versus alleged causative factors is that what causes what looks very different the closer in time and space you are to the events. So if you're a fly on the wall observing an event, so let's hypothesize that we did have a time machine, and that instead of having to cobble together a case through testimony and documents, which is basically all there is when you're doing litigation, you put together a case using whatever documentary evidence and maybe some material evidence, I don't know, like a sponge or whatever, but mostly it's documents and testimony. And that is collected many years after the fact. Now, if we had time machines, imagine that we could go back in time to the moment in the surgery. We might tell a very different story. And that's what I meant by real causative factors, is that we don't have access to those. Now, there might be a very close interconnection between real causative factors. That is all of the stuff that was involved at the moment of origin, the events of origin. But as time passes, there's less and less stuff available. Memory being one of them. So that's what I'm saying. I don't want to say that somehow by the distinction between real and alleged causative factors, I don't want to say that somehow what we do in law is not real or valid for that reason. I was just, maybe it wasn't the right word, real, or, but that's what I was trying to get at. And the best we can do in law is work with allegations carefully made via as many testimonial and documentary sources as you can get put together. So yes, I hope that helps.
Just for the sake of discussion, if Bernard or Ross want to weigh in, feel free to do so. If you have any additional comments to make, so I may not always see it if you want to interrupt, so you can just unmute and start speaking as well. But unless you have anything urgent to say, I'll take Murray Field.
It's Mark Geiger. I'll turn that off. I have a comment that I think might be interesting. For many years, as you know, Professor, I was involved with the negotiations with the OMA and the government and the CMPA. And the thing that I don't think has been properly considered here is the fact that, first of all, CMPA is not an insurance company for reasons that I've never understood. Secondly, they take claims based on when the claims actually occurred. So when you're insured as a doctor, although it's not insurance, when you're insured as a doctor, you're insured for anything that happens in the year that you were insured, no matter when it happens. And the third thing is that negotiations between the various medical associations and the governments across the country, the vast majority of the premiums, they're not premiums, but the amounts that are paid by each doctor are actually paid by the government. In Ontario, it's over 80%. And the premiums depend upon the practice. And the vast majority of payments that are made by CMPA are for damages in obstetrics, and they can occur, those damages can come to fruition 20 years after the fact. So you might think when you're doing this analysis, does the fact that the government is actually the one paying the vast majority of the amounts that are paid by CMPA as part of the negotiations between them and the various medical associations. And secondly, the fact that there have been negotiations, not just between the medical associations and the governments of the various provinces, but also involving CMPA. And I wonder whether that might be a very significant factor in the very big differences between payments that are made in settlements in the US as opposed to Canada.
Any comments from Patrick, Bernard,
okay.
or Ross?
Well, I'll let perhaps Bernard has some points, or Ross, and then I'll pick up.
Well, the contrast between the CMPA and insurance is important. The Canadian Medical Protective Association is what it calls itself, a protective association. That is, it protects its members. A lot of its funding, a lot of its work is protecting doctors against the medical disciplinary authorities, not just malpractice litigation in courts. In contrast, are the US insurance companies. And this feeds into an issue that was mentioned but not explored. Is there a medical malpractice litigation crisis? And the point was made many years ago, George Annis made it in the 1970s, that in the United States, although the rhetoric was of a medical malpractice litigation crisis, it really was an insurance crisis. That is, the insurance companies were involved. Now, the US insurance companies will tolerate nuisance actions. The lawyers are on contingency fees, so there will be a payment that satisfies the lawyers and leaves a marginal surplus payment to the plaintiffs. But if an insurance company thinks that it's cheaper to settle out of court than to incur all of the costs of mounting what would be a successful defense, then it's cheaper to settle than to defend. So even though the practitioner has done something that objectively is legally and morally defensible, it's a waste of time for the insurance company, it's a waste of money to litigate successfully when it could settle out of court at much lower cost. So the US insurance industry, medical insurance industry, has made a problem for itself in that it will tolerate nuisance actions and settle cases for low levels. Most of the payment on contingency fees going to the lawyers rather than the actual patients. And that provides an incentive. For example, the rhetoric in the United States is that a case that can't be won could still have a settlement value. That is, as a lawyer, you can make the life of the defendant so miserable, so embarrassing, that they will pay you money to go away. That is, if it's a claim against, let's say, a hospital, you can bring up a lot of litigation, a lot of evidence that you get on discovery, showing how the hospital has tried to cut costs, how the hospital has overpaid perhaps its own staff, executives on 7, sometimes 8-figure salaries, how money is being wasted and misapplied. And rather than have you dig up all of that dirt, they will pay you money to settle the action. So on its merits, the action may be fully defensible. There was no error, there was no negligence, there was no fault, but the claim has a settlement value. We don't have that in Canada, in that the CMPA will not settle cheap. They will happily spend vast sums of money defending a claim they could settle for petty change. They protect their members, and that is different from, and in many ways better than, in professional terms, better than having insurance.
Thank you, Bernard. Do you want to add something, Patrick?
Yes,
Or, okay.
If I could just ask one more thing, do you think it makes a difference in Canada that the money that's actually used to pay the settlements, the vast majority of it comes from the government as part of the negotiations between the government and the various medical associations?
Well, that could give the government an interest. We see it in the United Kingdom, where the Ministry of Health stands behind the doctors, and litigation against a doctor is litigation against the ministry. And that's a much bigger issue. It could be that because, for example, years ago, the Hospital for Sick Children in Toronto would pay 80% of the premiums of their doctors' membership of the Canadian Medical Protective Association.
Government does that now.
I'm sorry?
The government does that now. That's part
Yes.
of that's part of the agreement between the OMA and the government, and between other associations across the country.
Yes, and so the government then has an incentive to save money and to use money effectively, dealing with the sources of injury that the hospitals have to deal with because of health insurance coverage and because of standing behind the doctors. So the government is very much involved in this.
Okay, so Patrick, anything to add? Okay, so we'll go to a next question by Mary Fiedler, please.
Absolutely. So when I was reading your article, Patrick, you were in describing the methodological concerns and looking at malpractice cases. You described a lot of issues, within our adversarial legal system in advancing malpractice claims. So the inaccessibility of the legal system to many patients, legal triage, the creation of evidentiary narratives that sort of warp the reality of what occurred. And so I know that you specifically said in your talk that you don't want to get into causation or damages and remedies, but I'm trying to think systemically. If you think that malpractice claims are appropriately arbitrated within the adversarial system, and whether you see a better way of sort of understanding what occurred and helping patients cope with harms that they may have experienced because of clinical practice.
Well, thank you. That's an excellent question. I think it opens a lot of different doors that we could open and explore. I'll start by saying this. I believe that a well-tried case in court is a fantastic, it's really a cultural achievement. And what do I mean by this is that I actually believe in trials as an institution and as a practice. And I believe that when trials are well tried, when cases are well tried, and I'll get to what I mean by that after, I think that that is probably the most just thing that we can do as humans in order to hold ourselves to account. Now, well-tried case supposes that each side has adequate representation and is capable of actually making a good case, making their case heard. And so that is where much of the problem lies. So I strongly recommend to the law students who are in the room to read the work of Robert Burns. You can write to me if you want the reference, but Robert Burns wrote a number of books. One is called A Theory of the Trial, or he wrote another book, The Death of the American Trial. Anyways, so Robert Burns, unlike the vast majority of law professors, which is super interesting, actually believes that the trial is a good thing. The trial is usually seen as an incidental sort of nuisance. And in malpractice literature, I've even seen it called an expensive sideshow. So there is this sort of disdain, very cultured disdain of legal practices, the legal practice that is the trial. And this disdain comes along with a disdain of lawyers, which is more or less generalized across the population, depending on who you talk to, either begrudging kind of respect, fearful respect, or, anyways. I think that's incorrect. It's wrong, but that comes with a certain political philosophy that I can't get into here. But I think it's incorrect. It's blaming the trial as an institution for failures that are elsewhere. And here, once again, this is more of a systemic sort of argument. But if you observe the practices that go on in the trial closely, which almost no legal researcher does, vast majority of legal research is done on the basis of judgments, even worse, appellate judgments. So what happens in the trial, and the specific, dare I say, genius of the trial as an institution for revealing, to take Bernard's expression, for revealing the distinction between wrong decisions and decisions that were made wrongly, I think that the trial is really an important institution for that. And insofar that we are dissatisfied with the output of trials right now, I think it's a question of input failures. So if there is a market failure at the level of legal services, such that people cannot get adequate legal representation, then we ought not be surprised that trials don't, do what it is, don't live up to the ideal that I'm talking about. Because I think that the institution of the trial can live up to certain ideals, but right now a lot of things are set up such that it cannot live up to those ideals because of institutions that are elsewhere, namely the market for legal services. So anyways, I'll stop there because time is coming to a close, but thank you for your question. I hope that's helpful.
It connects also obviously to the debate around the role of the CMPA in filtering out what gets to the courts and what not. You speak to class action lawyers, they will, for example, who will work in the area of medical malpractice, they will say, well, when we think we will have an interesting case that may change, say, the particular legal theories of medical malpractice, and we want to put that forward, often the CMPA lawyers will actually close down court proceedings because they also know that once this goes up, and it's a sympathetic case for plaintiff lawyers, it will change the way medical malpractice is run in the country. So even the whole, I would say, the culture and the way we look at legal rules is being influenced by the market failures in a way.
100%. And that's only Trudeau knows this because he's the one who's been reading my dissertation. But this is why I'm advocating more generally. Not that we stop. I'm not going to be able to convince legal scholarship to change course. I'm fine with reading decisions. Keep reading decisions if that's what you want. Doctrinal research is very important. I also keep up with whatever the Supreme Court is saying. Kudos, everything is fine. However, there's an enormous blind spot. Once again, this whole discussion, my whole presentation today is about methodology, what is visible and what is invisible. Well, I would say that legal scholarship, by focusing on judgments and legislation, what becomes invisible there is all of the stuff that's upstream before the judgment, namely the trial, and not to mention all of the strategizing, the thinking, that goes on before the trial. And that is a domain of activity that is, just there, ripe for inquiry, but a complicated one. And how do we, how we sort of try to get a grip on that is once again where I'm saying, well, it's going to probably be a mix of systemic and observational in order to fully, get the best idea that we can of it.